And we have some breaking news coming in on the Aarushi Talwar murder case. The Supreme Court has agreed to hear the plea of CBI challenging the acquittal of Nupur Talwar and Rajesh Talwar in the Aarushi Hemraj murder case. The court has admitted CBI's appeal. Meenakshi Banja joining us now on the phone line. Meenakshi, a big development here in the Aarushi Talwar case. The top court agreeing to hear CBI's petition.
Well, absolutely, big breaking news coming in from the Supreme Court, with the Supreme Court now going ahead and issuing notices to the Talwars, formally seeking their response on CBI's plea as to why their acquittal from the Allahabad High Court should not be quashed or set aside. Now, this is something we had predicted first on Mirror Now, the fact that Court will go ahead and admit the agency's appeal the moment the CBI had decided to challenge the clean chit which was granted earlier by the Allahabad High Court. Now, this is going to be hugely interesting because our viewers will recall, one, there is no answer to really who killed Aarushi and Hemraj. And secondly, the trial court had come out with a very detailed finding in which it had found a mountain of circumstantial evidence to go ahead and indict the Talwars, which was not taken into account, according to the CBI, by the Allahabad High Court, and therefore the Allahabad High Court's judgment acquitting the Talwars was bad in law because a lot of cogent circumstantial evidence chain which the trial court had relied upon was completely ignored by the Allahabad High Court, and therefore this appeal had come about in the apex court. And given the fact that the trial court had convicted the Talwars while the Allahabad High Court had acquitted them, there were two disparate orders. It made for the Supreme Court to really go ahead and admit this plea filed by the agency, because there are two sharply differing disparate positions taken by two courts of law, and therefore the final arbiter on this will be the apex court, Urvashi.
Absolutely, and this is also coming in as a big setback for the Talwars there, Meenakshi, isn't it? Because now the Supreme Court admitting CBI's appeal, which was predicted earlier as well, challenging the couple's acquittal. Just help us understand, what does this really mean for the Talwars and the legal recourse that they can be expected to take in the days to come?
This is certainly worrisome days for Rajesh and Nupur Talwar, given the fact that perhaps they were drawing a lot of hope from the clean chit, and their legal strategy would be pretty much simple, that is to defend themselves again before the Supreme Court, to bring in the element of reasonable doubt and to rely heavily on the clean chit given by the Allahabad High Court. But clearly the CBI is not willing to relent pressure on this one. It has already upped the ante as soon as it decided to challenge the clean chit, and the trial court's judgment, Urvashi, would also be taken into account when debates, deliberations and arguments are happening on this one in the Supreme Court. Because remember, the trial court had come out with a voluminous judgment wherein it had gone on to cite a heap of circumstantial evidences, basis which it went ahead and indicted Rajesh and Nupur Talwar. So today the Supreme Court formally seeking responses from the dentist couple surely indicates that again the legal battle for them has not yet concluded.
Absolutely, the legal battle not yet concluded for the Talwars. Worrisome days ahead for them, Meenakshi. But if you could also tell us more about what were the points that have been contested by the CBI, if you could elaborate on that once again.
Well, Aarushi, as we have been showcasing to our viewers, the CBI is mighty upset with the blanket denial of a lot of circumstantial evidence which was taken into account by the trial court. For instance, there were purported tampering around with the scene of the crime when the police arrived on that fateful day and when this incident purportedly had happened. Then subsequently to that, there were several other circumstantial evidences which the trial court had relied upon, from the condition of the room to the bed on which Aarushi Talwar was lying, to even the clothing that was worn by the Talwar couple when they had discovered the body of their deceased child. So these were the circumstantial evidences, some of the circumstantial evidences that the trial court had taken into account, and also the fact that on the fateful day when the incident purportedly took place, there was no material to suggest any outside intrusion into the house. And these were the points basis which, some of the points basis which the trial court had gone ahead and indicted the Talwar couple. But subsequently, we had seen the judgment from the Allahabad High Court, which had given the element of reasonable doubt to the Talwar couple. The Allahabad High Court had categorically said that basis all the circumstantial evidences also, there is this aspect of reasonable doubt that lingers on. It is not proved beyond reasonable doubt the guilt of the Talwars, and therefore the benefit of the reasonable doubt should be given to the Talwar couple. Now that, according to the CBI's plea in the Supreme Court, is something which is erroneous and bad in law, because according to the CBI, insofar as criminal law is concerned, once a cogent chain of circumstantial evidence is made out against any accused, then their conviction cannot be set aside. And basis this, the agency had gone ahead and challenged this clean chit by the Allahabad High Court before the Supreme Court. And as we have been showcasing on Mirror now, it was a matter of time really before the Apex Court went ahead and admitted this plea, given the sharply differing and disparate positions both courts of law have taken on this one.
And this is a long-drawn legal battle that's ongoing, Meenakshi. It's been now over 10 years since Aarushi Talwar was found murdered in her residence. And we've seen multiple ups and downs in this entire case, as you mentioned yourself. And the CBI once again challenging their acquittal. This is, of course, coming in as a huge setback for the Talwar couple, Meenakshi, with the top court admitting CBI's appeal. They're finding some sort of some sort of substantiated submissions by the CBI, on the basis of which the top court in fact has agreed to hear this petition. Meenakshi, we speak about the CBI's case that was being built around Talwar. It was mainly around circumstantial evidence, and the defense that the Talwar had put out was that could the version of the CBI or that of circumstantial evidence prove that all the facts that it relies on can be established. All of these points were in fact very crucial in this entire case, Meenakshi, and all these points are going to be, of course, taken into consideration once this petition comes up for hearing.
Well, yes, it will be a long-drawn road ahead for the Talwars, but they really do not have any cause for worry insofar as legal representation goes. They have been represented adequately legally for years now. Rebecca John primarily being one of their top defense counsels. Then we have had some very, very eminent seniors also make appearances from time to time for the Talwars in the Supreme Court, from former attorney Mukul Rohtgi to even Harish Salve. And the Talwars essentially making the argument as to how they have no hand in any wrongdoing in any of the incidents that transpired on the fateful day, and they are the ones who actually went ahead and lost their daughter, to which they do not even have a reply till date as to who killed Aarushi and Hemraj. But on the other hand, the CBI is the agency, the lead agency on this one for several years. The investigating officers of CBI have really applied their minds on this one, and they feel that the trial court judgment in the Aarushi Hemraj incident is the one judgment which really is satisfactory, given the fact that the trial court has made a very detailed noting of its finding. Like we have been talking about the several aspects of circumstantial evidence which the trial court has taken into account. For instance, how nobody really entered the house on the fateful day. Then the condition of the room where Aarushi was discovered. Thereupon, even the clothing that the Talwars were wearing upon discovery discovering the deceased body of their child, being a few of them. And then, of course, the body of Hemraj, which emerged on the terrace just a couple of days after Aarushi's death was discovered. So these were the circumstantial evidences which the trial court had really taken into account. And because there are two sharply differing positions or points of view by two courts of law. Trial court convicting the Talwars bases a mountain of circumstantial evidence. On the other hand, the Allahabad High Court acquitting them, not finding enough grounds and giving them the benefit of the reasonable doubt. Therefore, the jurisdiction of the Supreme Court is made out very eminently on this one. And like we have been showcasing on Mirror now, because of these sharply differing positions, it will be ultimately the Supreme Court which will go on to settle the argument about who killed Aarushi and Hemraj.
All right, Meenakshi Banja, we'll of course continue tracking the developments pertaining to the Aarushi Hemraj murder case with you. Thanks for joining in. And